Hello, everyone. Happy Saturday. Thank you so much for joining us. So we've already got a good turnout. There's still a few people joining in. Just to make a brief introduction for myself and for Quest before we do bring on our speaker for today. My name is Colin Taylor. I'm actually one of the IRA specialists here at Quest. Frequently do these Saturday webinars, so if my face is familiar, maybe you've seen me at one of our other events. That's kind of my role with the company. But today we do have, I think, a really fantastic presentation for you with Mary Hart, talking about estate planning guide for real estate and note investors. So if you're in this alternative space, or maybe you're looking to get into it, this is just a great, I think, set of knowledge to have. So as we do go throughout the presentation today, while Mary's speaking, if you guys have some questions, feel free to post them in the comments, and then we'll get them up to Mary kind of throughout. So, as we're going, type your questions there, and we'll get them to her fairly quickly. And then we'll have some time for a Q&A, most likely at the end as well. But just wanted to make a note about that. So really quick, I do want to just give a brief disclaimer. This is common for all of our webinars if you've been with us before. But for those of you who are kind of new to hearing about Quest, or maybe the real estate side of investing in general, Quest Trust Company, we don't necessarily provide any sort of tax, legal, or investment advice. Really, the purpose of this webinar and the education that we do provide is just to give you more knowledge, more of an understanding, and that way you can kind of grow and develop in your real estate investor experience. But so please bear that in mind as we kind of go through the presentation. And like I said, because we do always have some new faces on, just a little bit about Quest. We are actually now one of the largest self-directed IRA custodians in the state of Texas, although we're not, we are primarily in Texas, but we do have investor clients across the country, a little over about 24,000 right now, and we currently hold just over 2.7 billion in assets under administration. So we're growing pretty quickly. That 110 employee mark is probably closer to 115 or 120 now, with about 34 of those being Certified IRA Services Professionals, or CISPs. That's a pretty rigorous test and study course that you have to go through to receive that certification. So certainly proud of that. And then currently we do have around $400 million in undirected cash. So, our for investor money. Am I still good? Mary, can you give me a thumbs up? Okay, perfect. So one thing I was mentioning about our education is that we do like to try to provide a lot of resources to the community. So I encourage you to check out our YouTube, our Facebook. So webinars like this, we record, we'll post on those pages, minutes after they'll automatically upload there. So we do host something every Saturday, oftentimes throughout the week as well. I really would encourage you guys to check that out. And then this is kind of some tidbits about some of our other events. Every Saturday like this one, we do a self-directed IRA Saturday. And then we have other socials and things like that going on throughout the week that are hosted hybrid. So we host them in person between Houston, Austin, and Dallas, as well as online. So I would encourage you to check out our events page. That that come at the end of the day, guys. I am really sorry. I must be having some internet issues, but this is a current promotion that we have going on right now. More details on our website about it. And then the last thing is, if you guys do have any questions, like I said, throughout the presentation, please post them in the comments. You can also reach out to us afterwards. My email is listed there. You can reach out to any of the other IRA specialists. But I think my connection is a bit, so apologize for that. I will go and pull down my presentation. That's kind of all that I wanted to go through, and we will get into Mary's portion of the webinar today. There's that. Thank you so much, Mary, for joining us today. We're super excited to have you back, and I'll you take it away.
Thanks, Colin. I appreciate it. And thanks to Quest for having me back. It's always one of my favorite places to speak. So thank you so much. And I'm coming to you guys live from a vacation rental, because when you get to be an investor and have a backpack business, you never know where you're going to end up. So I'm in one of my vacation rentals, and sorry, I'm in my bedroom, guys, but that's where the best signal is. So hopefully my signal will work today, and we'll get through this. But we're talking today about estate planning, and I'm kind of passionate about this, particularly for investors, because so many investors work so hard for so long, and they don't plan for the future with their estate plan or their disability plan. And I've seen so many instances in which wealth is dissipated and heirs fight and all these things happen. And so I like to proselytize a bit about the word of getting your estate plan done while you're alive and healthy, and being able to control what you want to have done with your stuff. So that's why we're talking about this today. And really, this presentation is not just for investors. It could be for anybody, but we'll throw in a few comments specifically for investors, things I've seen. But let's move on. So who am I and why do I know this stuff? I've been an attorney for about 32 years this month, actually. I'm currently retired from lawyering, but I am consulting. So I consult with people, mostly small business owners and investors, about estate planning and asset protection planning and investing and other things like that. I've been a real estate investor myself for a little over 20 years. I was a 1031 qualified intermediary for 19 years, but I've shut down that business. I do have a real estate license, although I don't use it for anybody but myself. And I founded a mentorship program about a year ago now called the AIM Higher Academy, the Alternative Investing Movement, where we go through a lot of education for investors. So that's me, and that's why I know this stuff. And here's my legal disclaimer. I'm not your lawyer. If I were your lawyer, you'd be paying me $500 an hour to be here. So since I'm doing this for free, you can't sue me for any of this advice. It's just education. All right, so let's talk about what our estate planning objectives are and why it's important to do this estate planning. People think of estate planning as like something just rock stars do, or they might think, I don't have enough money, it's not worth doing an estate plan. But an estate plan is so much more. We accomplish your personal and family goals. We try to avoid the probate process, which comes with a lot of costs and a lot of tediousness and headache. We want to minimize or avoid estate and gift taxes, which, by the way, the top estate tax and gift tax bracket right now is 40% and going back up. We want to do some income tax planning if possible, usually through the use of some trusts. Disability planning to make sure that someone can take care of things for you if you become disabled, whether that's temporarily or permanently, and are unable to make your own decisions. And then legacy planning, what do you want to leave on this world when you're no longer in it? What's your imprint? And that could be financially, it could be the way you live your life, but all of that comes through estate planning, a lot of it. So those are our goals. Some of the other ones, actually, I thought I was finished, but I'm not, because there's so many more. We do want to maintain death with dignity. You guys have heard the stories of people who are kept alive for years in a coma. They don't know where they are. They're either unconscious, or even if they are conscious, they are totally out of it. So we want to make sure that at the end of our life, we are dying with dignity. Usually we want to maintain control to make sure that what we want to have happen with our wealth and our bodies and everything is in our control, or we've named the people we trust when we are no longer able to control that ourselves. We want to decide who inherits all these investments and these IRAs and everything you've worked so hard for. Is it your children? Is it your charities? Is it nieces and nephews, friends? And how do they inherit? Are they okay to get the assets outright? Can they manage it? Or do we need to leave it in trust for them? And if we do leave it in trust, who the heck's going to administer that estate or trust long after our death, potentially? And who would the successor be if that person is not able to continue? So you can see that there are just a lot of things that we take into consideration when we're doing your estate plan. I call it the ultimate love letter. And I say that just because truly, I think it is the nicest gift you can leave your loved ones is to take care of all of this stuff ahead of time. Excuse me, it's pollen season here and I've got a tickle in my throat. To take care of all this ahead of time so that your loved ones can just go about the business of grieving your loss and not having to deal with some of the tediousness that comes up if you don't do your estate plan. And I'm going to take a sip of tea real quick. So in 30 plus years of doing estate planning, there are two biggest mistakes that I've seen. The first one is just a failure to have a plan at all. And we see that all the time. You see it when musicians die or rock stars die, actors die, and the news comes out that, can you believe it, they didn't even have a will. It's very, very common. I think there's a small percentage of people in our country that have actually gone through and done an estate plan. And that is really a shame. So I want to encourage you guys, and I have lots and lots of war stories. I don't know if we'll have time to get into them that would, if nothing else, scare you into getting your plan together. But the second biggest mistake is if you're doing your plan or thinking about how you want things to pass at your death, it's not understanding how assets pass at death, what documents are used, whether it's your will or some other document. And, we all have a good reason for not knowing this because nobody teaches us this stuff. This is not something we learn in school. And it's not always intuitive how things pass at death. So I'm going to kind of beat that one like a dead horse. Hate to say it that way, but I want you to really understand that because that is a huge mistake that has, even when people have done their estate plan, if they don't understand how things pass at death, their estate plan as they intended it often is not put into place. So when we're trying to decide how an asset is passed at our death, it comes down to the way the asset is titled, how it's owned. We want to make sure that we use the right titling and the right documents to pass the assets the way you intend. So to know how those assets are going to pass at death, the first thing you have to do is really know what you own. Now that sounds pretty simple, but I can't tell you how many clients we go through the list of all the assets and, an hour or two into the meeting, they would say, well, I forgot about that $2 million IRA I've got at Quest Trust Company. So people do forget because we don't look at it every day, what our assets are. So you need to know what you own, how you own it, how it's titled, and use the right document to pass it after your death. What I encourage people to do as homework is to just pull out an Excel spreadsheet on your computer and write down every asset you have an ownership interest in, how you own it. Is it in your separate name? Is it owned with somebody else? And we'll go into detail about that in a minute. I used to like to add how much is it worth, how much debt is on it, so you get a net worth of that asset, and so on and so on. So you can look at your sheet, and once you know how different titled assets pass, then you can look down your spreadsheet and know whether or not you have the right documents that you're using. So there are obviously a number of ways you can own an asset. If you own something in your separate name, like let's say I own my house in the name of Mary Hart with nobody else on the deed, that is what we call a probate asset, and that's going to pass through my will. But what if I own that house as a joint owner? Somebody else's name is on the deed, say my husband, Frank Hart. If somebody else's name is on that deed or that bank account or that stock account, then I have to look and see, well, does that person have a right of survivorship? You might see it on a stock account. It might say Mary and Frank Hart, JTWROS, joint tenants with a right of survivorship. If that language is in the titling document, then the moment I die, my husband would inherit that asset the moment I took my last breath because he has a right of survivorship. So if it's in the joint names with somebody else, is there a right of survivorship or not? If there's no right of survivorship, then your portion of that property is treated as if it's in your separate name and it goes through your will. Do you own an asset that's in a trust and you're simply the beneficiary? If so, it'll pass through the trust terms, not through your will. Is there a pay on death beneficiary? Say like your IRA, does it have a beneficiary designation? Your life insurance, things like that. So when we're planning for death, we need to know how something's titled because that will tell us what document is the appropriate document to use to direct where that asset goes when we die. So here's a nice little chart that might help you. And like I said, I'm kind going over this a lot because this is a huge mistake. And sometimes it's hard to incorporate into our mind because we don't think about it every day. So let me just go through all this again. If an asset is titled in your separate name, again, I'm going to use my house in the name of Mary Hart, then it is either going to pass through my last will and testament to my devisees. That's what they're called. I am devising this asset to them. But if I don't have a last will and testament, it will go through the laws of intestacy, which is the will your state legislature has created for you, and it will pass to your heirs at law. So if you don't have a will, it's still going to, but it's in your separate name, it's still going to go to people that the state chooses. If you have a last will and testament and you die with something in your separate name, your asset will pass to the people you have chosen. That in and of itself is a good reason to have a will, because you want to make sure that you are in control of who gets your assets and not just following the state mandate that you may or may not agree with. So if this house, again, is in joint names with the right of survivorship and I die, then it passes automatically to the surviving joint owner by operation of law through that deed. So Mary and Frank Hart as joint tenants with the right of survivorship. I die, it's going to go to Frank Hart. If he died first, it would go to me. It happens automatically. So even if I have a will that says I leave my half of the house to Colin, Colin's not going to get it. It's going to go to my husband because of the way it's owned. If we own that house, both our names are on the deed, but it says as tenants in common, and let's say it's 50-50, then it's going to be treated as if my 50% of the house is in my separate name and will pass through my will. And my husband's half of the house will be considered in his separate name and pass through his will. So you have to read the deeds carefully. And if it doesn't specify whether it's a right of survivorship or tenants in common, then you have to see what your state's default law is. How is it treated? In a lot of states, if you're married, it's treated as a form of survivorship, right of survivorship, even if it doesn't say that in the deed. But that is governed by state law. So you'd have to ask an estate planning attorney in your state how it passes if it doesn't say. If something is titled in the name of a trust, like let's say my revocable living trust, if this house was titled to Mary Hart as trustee of the Mary Hart Living Trust, then it's not going to pass through my will when I die. It's going to pass to the trust beneficiaries. However, I have written that out in my trust document. That's going to be the governing document. If I had an asset with a beneficiary designation like my IRA or my 401k or life insurance policy, or sometimes stock accounts or bank accounts can have a pay on death beneficiary, then it will go according to the terms of that beneficiary designation. So again, all these things that pass by documents other than your will, you can't change how that passes by putting something different in your will. And I'll tell you a quick story just to bring home that point. When I was a very young attorney, I was practicing in Alaska, and we had some state of Alaska benefits that were like retirement plans for state workers, and they were quite significant. And I got hired by two young men in their 20s whose mother had died very unexpectedly in a scuba diving accident. And her mother had left a partner. And in the beneficiary designation for her state retirement benefits, she had originally said, okay, the kids get 75%, the partner gets 25%. Years later, she did a will, and she changed that in her will to say that the partner should get 50% and the kids could get 50%. When she died, of course, the will did not govern because it wasn't governed by a will. It was governed by the beneficiary designation form. So the partner thought she was getting 50%, but she was only getting 25%. So she sued the sons, and the sons hired me. Well, by law, those sons were entitled to 75%, even though everyone knew that the intention from the mom was to name her partner for the other 50%, not just 25%. But the designated beneficiary form controlled. So had this gone all the way to court, the partner would have lost, there's no doubt. But the sons, liked her and wanted to settle. So we ended up settling somewhere in the middle. But it took a lawsuit to get there. So this is why it's so important to understand that certain things pass outside of your will, and you cannot use your will to designate where those things go. So again, if it's with a joint owner with a right of survivorship, it will pass outside the will. If it's in a trust, it will pass outside the will. If it's a designated beneficiary form, it'll pass outside the will. You see where I'm going with all that. So on to the rest of the chart. You guys may have seen a deed that gives someone a life estate. Like if I took my house and I said, I'm going to deed to Colin my house, reserving a life estate to myself. That just means I have the right to live in my house for the rest of my life, and I pay for it. But when I die, my life estate is extinguished at the moment of my last breath, and now Colin owns the whole thing. You see what I mean? And Colin, in that case, would be considered the remainder interest holder or the remainderman, and that's my last box here on this chart. So you can see that it becomes very, very important to really pay attention to what it is you own and how you own it, and what type of document controls how it passes at death. Very, very important point. All right. So with your self-directed IRA, generally speaking, you will have filled out a designation, a beneficiary designation form. And if you haven't done that, please rush to your custodian and get that done, because that is the best way to pass your IRA. You need to make sure that you not only name a primary beneficiary, but at least one contingent beneficiary in case the primary beneficiary dies before you. There's this interesting phenomenon in estate planning where somehow everybody thinks they're going to be the first one to die, and they don't realize that they may actually be the survivor. So name a primary beneficiary, name at least one contingent. I personally like to have at least two contingent beneficiaries, but at least name one. Review those beneficiary designations periodically to make sure they still say what you want them to say. There are plenty of stories where people get divorced and never remove their spouse as the beneficiary, and they never got remarried, and now their ex-spouse gets the retirement benefits. That was never the intention. Pretty much never name your estate as a beneficiary. You might think it's easier to say, well, I'm just going to name my estate as the beneficiary, and then that will make it pass through my will. But there are tax laws that makes that not beneficial. The entire IRA would probably have to be distributed out faster than you want it to. And if it's a traditional IRA, then it's taxable to the beneficiary as it comes out, ordinary income tax. And if we name the estate as the beneficiary, it's either got to be paid out within 1 year or 5 years, the whole account, no matter how big it is. So normally we don't like to name the estate as a beneficiary. You just want to name the individuals themselves on the form. You can name a trust as a beneficiary. It has to meet certain rules. And as I'll talk about a little bit later, when they passed the Secure Act a few years ago, and it eliminated the stretch out of using a trust beneficiary's life expectancy to stretch out the minimum payments and dropped it down to 10 years, then the use of trust became much more problematic. So we're always trying to balance. Do we need a trust to protect the beneficiary and control things? That's balanced against the simplicity and the better tax consequences usually of leaving it to the beneficiaries outright. So that's a big conversation to have with your estate planning attorney. If you have, say, minor beneficiaries, disabled beneficiaries, beneficiaries who are what we call spendthrifts. They don't save money, they spend wildly. You've got to balance that interest of leaving something in a trust, leaving a retirement benefit in a trust to protect the beneficiary, but trying to do it in a way that is the least tax consequences to that beneficiary. That could be a whole presentation in and of itself. So we won't get into great detail about that. Just flag it as an issue and talk to your estate planning attorney about it when you do your estate plan. Okay. Every single person, in my opinion, who's 18 or older should have these documents we're about to go through. And this really hit home to me, although I'd been teaching it forever. But when my oldest son, who's now 31, turned 18, on his 18th birthday, it was my first child, 18th birthday, he had to have his wisdom teeth removed. And I took him to the oral surgeon, and I start filling out all the paperwork because I'm the mom. That's what I always did. And they said, well, you can't fill out that paperwork because he's 18. And he was like, oh my gosh, I know that. I've taught that for 100 years. But I just wasn't thinking about it with my own child. So I could not sign any of the paperwork. And I realized if something happened to this kid, in my mind, still this kid who's 18, I have no legal authority to act for him. So for his 18th birthday, he got an estate plan because I went right back to my office after I took him home and did his estate plan for him. And my other two sons also got estate plans for their 18th birthday. So If you have someone in your life who's 18 or over, or if it's you, you should have at least the following documents. You should at least have a last will and testament that governs anything in your separate name. You should have a healthcare power of attorney that allows you to appoint the person who will make this healthcare decisions for you if you are unable to make them yourself, whether that's for an hour or the rest of your lifetime. Without that document, if you have a medical need and you can't make your own decisions, someone has to go get appointed as your guardian. And that's a lawsuit. That's filing a lawsuit in court and proving to the court that you are incapacitated and proving to the court that they are the appropriate person to have the healthcare power of attorney and make your decisions for you. Except it would be a guardianship in that case, not the power of attorney. I can't tell you how many families I've seen fight at this point, where each child thinks they have the right to take care of mom or dad. And it's just better if you choose who makes those decisions for you, maintain some control over that. So healthcare power of attorney is very, very important. The living will, that's what we very crudely call the pull the plug document. So in North Carolina, where I am right now, we call that the declaration of a desire for a natural death. You don't want to be kept alive artificially. It's a very personal decision, but if you would not want to be kept alive artificially by tubes or IVs or breathing machines or anything like that, then in order for your wishes to be enforced, you really need to have one of these documents on file, or at least have signed one. So very important document if you don't want to be kept alive artificially. The HIPAA waiver for your healthcare agent. You guys might remember, this was a long time ago now, probably in the 90s, we had the Health Insurance Portability and Accountability Act that came in, and you might not remember that name, but you might know what it is, whereas every time you go to the doctor's office, you have to acknowledge your privacy rights. Well, we worry that your healthcare agent won't be able to get your medical information to make appropriate decisions. So we like to also have you sign a HIPAA waiver for your healthcare agent, giving them the authority to get your medical information so they can make an appropriate decision for you. Other things to take care of or to make sure for those assets that have the beneficiary designation, like life insurance, IRAs, 401ks, things like that, that you have filled out your beneficiary designation. You may also want to use a revocable living trust to avoid probate, and we're going to go through that in a minute. But that's an optional document, but in a lot of states, it's more important when the probate process is more onerous. So we'll talk about that here in a minute. All right. So I mentioned this earlier, but I want to reiterate this, because if you die without a will, your state has created an estate plan for you. That is called the laws of intestacy, and your state legislature has decided who will inherit your separate assets, things that are in your separate name, if you die without a will. They try to come up with what they think would make sense. Like if you're married and have children, there's usually some split between your spouse and your children. If you aren't married but have children, it usually goes to your children. If you don't have children but you're married, in North Carolina, it goes to the spouse and the parents. So there's this whole hierarchy of who gets what if you die without a will. So those heirs at law, the people that the state has said will inherit, may not be the people that you want to inherit, or may not be in the same percentages that you would want them to inherit. Your intestacy will does not create trusts for anyone, does not appoint guardians, does not deal with pets, all that kind of stuff. So this is why I highly encourage people to do your own will. And it can be fairly simple even, but you need to be able to control what happens when you die. Because when there is no plan in place, there's so many times, and I say it here, strife and estrangement between family members. I see it all the time. When grief and greed collide, it is not a pretty picture. It just isn't. And, hopefully families will all get along, but I cannot tell you how many times I've dealt with lawsuits where kids are suing each other and they hate each other. They'll never speak again the rest of their life because the plan wasn't put in place and everybody's arguing about what should happen. So if you fail to have an estate plan, in many cases, your estate will incur unnecessary expenses, taxes, fees, the loss and dissipation of your hard-earned wealth that you guys as investors have worked so hard to gain, and many times will result in estrangement between family members. So please do your estate plan. For the most part, it is not a do-it-yourself project. And the reason is because it involves not only personal and family goals, but taxes and probate. And there's just a lot of moving parts that we're not taught about in school or in any walk of life unless you seek that information out and learn it yourself. So I highly recommend that you hire an attorney to do your estate plan, even a simple one. You can do wills on LegalZoom or other online programs, but I will tell you that in my 32 years, every single will contest I saw or trust lawsuit I saw, all involved wills or trusts that were either written, handwritten, or written on LegalZoom type program, not with the assistance of attorney. Every single one, because we don't know what we don't know. And we know what's in our head, but we put it down on paper and it makes sense to us, but it might not make sense to anybody else. It might be vague, and vague documents are not enforceable documents. And vague documents allow people to argue. So I highly encourage you to hire someone to help you. And it's not a plug for me because I'm not hireable as an attorney. So this is, I'm hireable as a consultant, but just find an estate planning attorney in your state to do this plan for you. All right. So let's talk a little bit just about the difference in these advanced directives for healthcare. We talked briefly about the healthcare power of attorney. That allows you to appoint someone to make your healthcare decisions if you can't make them. It has no legal effect until you become disabled or incompetent and unable to make your own decisions. You can appoint more than one person to act together, or you can appoint more than one person to act in succession. Either way. The living will, we talked about the pull the plug document. People tend to confuse that with the do not resuscitate order. DNR, do not resuscitate order, is a document you actually get with your doctor if you have a terminal condition that means you don't want to be resuscitated. If you say you're dying of cancer and you have 2 weeks to live, but you have a heart attack in your kitchen. You don't want to go through all the trauma of being revived when you have a life sentence, really, you're dying. So your doctor will do that with you when you're in a terminal situation, and that is renewed usually annually. That's not the same thing as a living will. If you don't have a do not resuscitate order and you have the heart attack in the kitchen, the paramedics will do their best to resuscitate you, will take you to the hospital, put you on life support, and it's only when it's determined that you have an irreversible condition that would otherwise cause your death within a relatively short period of time that the living will would kick in to say, remove the life support. So those are just very different documents. We talked about the HIPAA waiver. The most or medical order for scope of treatment is a form you do with your doctor to get into some details about how you would want medical treatment. And we talked about the fact that if you don't have these advanced directives in place and somebody needs to decide something for you, it's going to be a court action and a guardianship proceeding. And that is incredibly traumatic, by the way. If you don't think anything's wrong with you, let's say you're conscious, but you have severe dementia and someone needs to take care of your healthcare decisions or your financial decisions, and you have not gotten any advanced directives in place, someone has to go seek guardianship, and they first have to prove that you're incapacitated. Well, if you don't think you're incapacitated and your children are trying to prove you are, that is a very, very stressful, traumatic thing to go through and can also tear apart families. So just keep that in mind. All right, the durable power of attorney is like the healthcare power of attorney, but it's for everything other than healthcare decisions. So who's going to pay your bills? Who's going to hire the landscaping company? Who's going to, deal with your Quest Trust account if you need to change something? And so this is an incredibly important document, and you can make it so it's effective either the moment you sign it or only if you become incapacitated later. If you make it so that it's only effective upon your disability, then of course your disability has to be proven. And that's usually proven by getting you in to see a physician and getting an affidavit from that physician that you are incapacitated. That is more protective, but it also can hold us back if we need to act quickly. And in the world of real estate and note investing, a lot of times people have to act quickly. You've got a closing the next day, and all of a sudden you get hit by a bus and you can't sign that document. Is the closing going to wait for a month or two before he can get you in to see the doctor and get that doctor's affidavit? Maybe not. So just kind of keep that in mind. Just like the healthcare power of attorney, you can appoint co-agents or successor agents. So those are the advanced directives, and that deals with what happens during life. Now we're going to talk about wills. Let's see, we got a question first. I have a last will and testament and other estate planning documents that were drawn up when I lived in Texas and now I live in Florida. Is that will still valid and enforceable? Probably so, yes, because each state has what they call the full faith and credit clause, where they have to give full faith and credit to the laws of other states. So if your estate planning documents were validly drawn up in Texas, then Florida should recognize them. Now, that being said, I also recommend that you have a Florida lawyer just look them over to make sure, just to make sure, because it's too important. And that's buying an hour of an attorney's time to say, hey, can you look at these documents and make sure they'll be given effect in Florida? So, but generally speaking, you should be okay. All right. So let's talk about wills. We talked about it a little bit earlier. What does a will do? It provides for the distribution of property owned by you at the time of your death in any manner you want it to go. But remember, it only covers those assets held in your individual name at death, not in a trust, no surviving joint owner, no designated beneficiary, things like that. So keep in mind, only those assets are covered. You can also do other things through your will. If you have minor children, you can designate a guardian. I've seen wills where there's a divorce situation where we've actually said that if, let's say the person drafting the will has sole custody for a good reason, then we've actually put in the will that the ex-spouse should not get custody of the children if the first person dies, unless it is found to be in the best interest of the children. So you can designate your executor, what is often called the personal representative now. And if you do that in your will, you can eliminate the need for that executor to post a bond out of their own pocket. The bond is kind of like bail bondsman. It's the guarantee that the executor won't run off with the estate's money. So the executor, if you don't have a will, then the executor is going to have to post a bond and pay for it out of their own pocket. But the will, you can eliminate that if you trust the person you've named. You can create trusts for minor children or special needs beneficiaries so that they don't end up owning these assets outright when they're 18. You can provide for charities, of course, and we can accomplish estate and income tax savings, provide for pets. I have clients who've done pretty extensive trusts for their pets, which is always interesting. So I know I'm hitting this hard, but remember that your will not pass title to any asset that's not in your separate name. So don't write a will that's all comprehensive and then think it covers everything. It will not cover things that are not held in your individual name. All right. So I think this is probably about my last slide on this, but what does not pass by will? Joint ownership that has a right of survivorship, assets with a designated beneficiary, assets held in trust where the trust names a beneficiary, or assets that have a pay on death beneficiary form filled out, like a pay on death account. Can you elaborate more on if the estate is the beneficiary? Somebody just asked that question. I don't know if you're speaking in context of the IRA, naming the estate as the beneficiary of the IRA. That's what I was referring to when I talked about it earlier. And if let's say it's life insurance or something that is not an IRA type account or a retirement account, it's fine to name your estate as the beneficiary of that, of a pay on death account, of a life insurance policy, anything that is not a qualified retirement plan, like an IRA or a 401k. The reason we don't want to do it with an IRA or a 401k is because the law, the tax code basically says, if you name something that is not a quote designated beneficiary, and that's a term of art in the tax code, if you name something that's not a designated beneficiary, then it has to be paid out either within a year or 5 years, depending on what the plan document says. So your estate does not qualify as a designated beneficiary, capital D, capital B. And so then we have that rapid payout. And if it's a traditional IRA that has not paid income taxes, then as that money comes out, it is subject to income taxes. And we may be piling money into a beneficiary's income taxes more rapidly than we would otherwise have to. So that's why we don't want to do that. All right, next question. How does investment real estate pass to a beneficiary that's held in the LLC? So an LLC does not have a beneficiary, but the LLC itself will pass by whatever your estate plan says or by the laws of intestacy if you don't have an estate plan. So for instance, I have a lot of LLCs with a lot of real estate in them. My LLC, if it's just in my name, I'm the only member, then when I die, my LLC would pass through my will. And let's say I leave it to my husband. So now he would inherit the LLC through my will, and whatever's in the LLC, he inherits because he inherited the whole LLC. So he gets the LLC with its real estate and its bank account, or whatever else is in there. In my case, because I'm trying to avoid probate, I set up a revocable living trust, which we'll talk about in a little bit. And that trust, me as the trustee of that trust, is the member of my LLC. What does that mean? That means that my LLC is owned by my trust. So now it's not considered in my separate name. So it's not going to go through my will. It's going to go through the terms of the trust. So if the terms of the trust says I leave my all my assets to my husband, it would pass to my husband, just like it would through a will if I left it to him, but no probate. If I said I leave 25% to my husband and 75% to my 3 sons, that's how it would go, whatever it is. So the LLC will pass by whatever your estate plan is. And if you don't have an estate plan, it'll pass by the laws of intestacy. And then whoever ends up owning that LLC will own all of the assets owned by the LLC, right? Can an LLC pass to a trust upon an owner's death? Absolutely, if the estate plan is set up that way. Yes, so let's say that I wanted to leave my LLCs in trust for my 3 sons. My estate plan would say, I leave all these LLCs to my sons, or I leave it in trust for my sons, or whatever you want. Every asset can be left almost any way you want it to. Retirement plans have a little more difficulty, but it's just all in a matter of doing the right documents, your will or your trust or whatever it is. And that's why we want to figure out what do you own? How do you own it? What's the right document to pass the ownership of that when you die? That's why it's so critically important. You can do the best estate plan in the world, but it won't mean anything if you did the wrong documents because you didn't know how assets passed at death. Okay. All right. So we talked about this. If you die intestate, you die without a will. So anything that would go through the will, if you had one, will pass by the laws of intestacy to the people the state legislature says should inherit. Everything that passes otherwise will pass outside of probate. And we've talked about that to death, the joint ownership, the trust, the designated beneficiary. All right. So these are reasons why you might want to not just count on the legislative will, why you might want to have your own last will and testament or a living trust coupled with a will. And we'll talk about that in a minute. If you have different beneficiaries than the state says you should leave to, let's say, I have stepchildren, or I might want to leave something to charities, some of my friends, or I want to take care of my pets. The legislative will is very simple. It's lineal descendants and ancestors, basically. And sometimes your aunts and uncles, if there aren't any descendants or ancestors. But if I want to change that, then I need to do that through an estate plan, whether that's a will or a trust. If I want to leave specific bequests of personal property, who gets the stuff? My engagement ring goes to my daughter so-and-so. My antique rug goes here. I'd need to do that through my estate plan. If I want to be able to choose the guardians for any minor children, I would do that through my estate plan. I might not want to put family members in a bad tax position. Maybe I have an estate that I want to go to my child, or the legislative will would leave it, say, to my child, but I want my child to split it among other people, friends or whatever. Well, he might be making a taxable gift if I leave it to him, but then he gives some of it away. So these are all things that you take into consideration, and you can control through your own estate plan rather than relying on the state law estate plan. We can put trusts in there to protect beneficiaries or for tax or non-tax reasons. We can do trusts for the retirement benefits, but like I mentioned earlier, the Secure Act has made that much more difficult and less practical. So that would involve a long conversation with your estate planning attorney to see what works best for you. Estate tax planning opportunities we can do through your estate plan, and that credit shelter trust I mentioned there is just, we don't have time to get into the details of it, but it is a type of trust that we use in some cases to make sure that we're doubling the amount of assets we're passing estate tax free when we have a married couple. Right now, each person in this country that's a U.S. citizen can leave $12,920,000 to anyone. Okay, that's going to change in 2026 and drop back down to $5 million index for inflation. But let's say if you had a spouse and one spouse died and everything passed to the surviving spouse, we may have wasted the first person's ability to get that money out. So the credit shelter trust is just one of the ways we deal with that. All right, let me see if I can see this question. It's kind of behind my slide thing. When mom dies and her brokerage was in her irrevocable trust and the sister is the trustee, what to do when the sister will not give the 50% beneficiary any money? What to do? Call a lawyer, because they are breaching their fiduciary duty, which is a massive no-no. If they're not following the terms of the trust, they can be sued and they can be removed or ordered to do what the trust says. That's clear as day. You need to call an attorney. And because that's unless there's a reason, that should not happen. Okay, let's move on to the next set. So other reasons, things you could do in your estate plan is trust for charities, trust for, say you have beneficiaries that are qualifying for Medicaid or disability benefits. And if you leave money outright to them, it might disqualify them for their government benefits. So there are certain types of trust where we can leave money in trust for a disabled loved one who's getting government benefits in a way that will not disqualify them from their, say, Medicaid, but provides extra funds to pay for things that Medicaid doesn't pay for. So that's kind of an important one. Q-tip trust is a way to leave assets in trust for your spouse, but ensure that the beneficiaries you choose ultimately get it after the spouse dies, whatever the spouse doesn't need or use. That happens. We see that a lot in blended marriages, second marriages. Like mine, I have a second marriage. So I have 3 sons, I have 3 stepchildren. I want to make sure that whatever it is, if I'm leaving it to my 3 kids or to all 6 kids or whatever it is, that I can control what happens after my spouse's death when we're both gone. So that's a Q-tip trust. All right, so let's jump right into trusts. I find that people get confused about what a trust is. It sounds complicated and scary, but a trust is just a contract. You guys are all investors. You know what contracts are. It's just a written contract, and the parties are the grantor, the person who sets up the trust and puts the money in, the trustee, the party who manages the trust, and the beneficiary, the person who gets the trust assets at some point, either presently or in the future. Just a contract. So like anything else, you can have an oral trust without writing, but that's really, really difficult to enforce, and I never recommend it. But it's a contract. So it's just a trust document that says how these assets are administered during one period of time, say when the grantor is alive, and then what happens when the grantor dies. There are many, many types of trusts for many, many types of purposes. So I'm just going to keep this simple today. So you created, as I said, was a written document signed by the grantor and the trustee. These trusts can either be set up during your lifetime, that's what we call inter vivos, during life, or they're part of your estate plan, but they don't kick in until you die. So that's a testamentary trust that pops to life at your death. You've pre-written the terms of it, but it's a sleeping trust until you die, and then it comes to life after your death. You can have trusts that are revocable and amendable, or trusts that are irrevocable and unchangeable. And there are many different reasons why you choose one or the other. What I'm going to talk about today is the revocable trust, often called the living trust. It's the standard of what people do for an estate planning trust. Okay, so another question. If I have a house that does not pass through the will, if I have a house, does that pass through the will, or do I need the trust? Classic lawyer answer, that depends. If the house is in your separate name, like your name's the only one on the deed, then it's going to go through your will, and it will go through probate, which can be a very costly, time-consuming, and tedious process. If you want to avoid probate, you can set up a revocable living trust and deed your house into your revocable living trust, and then it will pass on your death according to the terms of your trust in a private trust administration. There's no probate. There's no public notice of what's in your trust. It's all private, and we can take care of that in an hour as opposed to a year or something like that. So whether you need a will or a trust depends on your personal situation, and it's something you should discuss with your estate planning attorney. For me personally, having done lots and lots of probates for lots of people, I choose to do everything in my power to avoid probate when I die. And I'll give you an example why. Both my parents recently died in the last few years, and we had set everything up in revocable trust for them to avoid probate. And there's 6 kids, and it could get messy. Well, the only thing that got left out was one car worth about $5,000. And it's taken me almost 2 years to get that car transferred. It's ridiculous because it had to go through probate, and it had both my parents' name on the title to the car. So we had to reopen my dad's estate and then open my mom's estate and sign all these documents just so I could give the car away. We were trying to give it away to my mom's good friend. So that was a pain in the rear end that could have been avoided had she had the title, and we could have transferred that car into the trust before she died. So probate is not fun. All right, what was the name of the trust you mentioned, which has 12 million now, which will go to 5 million later? It's not a trust that has that. I'll explain. That 12,920,000 is the amount of assets each person currently can pass to anyone free of estate taxes. That amount, we call that, there's an applicable tax credit that shelters 12,920,000. That amount is going to drop down to 5 million indexed for inflation at the end of 2025. So January 1st, 2026, instead of being able to pass almost 13 million, we're now back to 5 plus inflation, whatever that makes it, 6 million or whatever. The trust I was mentioning, it's just one way that we can guarantee that each spouse gets to use their tax-free amount. So let's say it's after 2025 and each person has $5 million that they can pass, or whatever inflation says it is. Let's just call it 5. And let's take my husband and me. So let's say that I died and I left my 5 million. Let's make it 7 million, make the math better. I leave my 7 million to my husband. It'll go free to him because he's my spouse and I have a marital deduction. But now he's got the full 7 million. So when he dies, he can only leave 5 million. So there are a few ways that we can solve that and double it so that my credit gets used. I can get my 5 million out and he can get his 5 million out. The one I had mentioned was a credit shelter trust. That's the name you were asking me about. It's also called a bypass trust or an AB trust type of plan. Sometimes we don't need to use an actual trust. It's way more than I can go into right now, but there are about 3 different options that we can use to make sure that we use both my credit and my husband's credit, or in your case, your credit, your spouse's credit if you have a spouse. And so, but that trust I mentioned was a credit shelter trust. Okay, we've talked about the definitions, so I'm not going to do that. These revocable living trusts are called grantor trusts for tax purposes. So they are ignored for tax purposes, and all income and deductions are taken on your personal return. So because it's ignored, if you sell your primary residence, and it would qualify for exclusion of capital gains under Section 121 of the Internal Revenue Code, the trust gets to exclude those capital gains. You don't have to pay rent to live in your house owned by your trust. All right, I have another question. After a revocable living trust is set up, when we start new LLCs, can we simply name the trust as the owner, or does it have to be funded into the trust? Same idea. When you start a new LLC, rather than you being the individual member, your trust, or you as the trustee of your trust, is the member of the LLC. So for instance, my LLCs have Mary Hart as trustee of the Mary Hart Trust. That's not what it's called, but Mary Hart as trustee of the Mary Hart Trust is the member of my LLC. So you can do that at the beginning, or you can do it later. All right. So we talked about the fact that when you set up this living trust, revocable living trust, or RLT, sometimes we call it, and you put your assets in it, you retitle the assets in it, whether that's your LLC or your house or your bank account or anything else. You've now taken those assets out of your separate name and into your name as a trustee. Right? Because usually with these trusts, when you set it up, you remain the trustee and the beneficiary. So you're everything, the grantor, the trustee, and the beneficiary, so long as you are alive and competent. And so when you transfer assets into that trust, it takes them out of your individual name and into your name as trustee. That's what takes it out of probate, because now it's not going to go through your will. It's going to pass according to the terms of your trust. And that can be changed over time. You can change your revocable trust as long as you're alive and competent as many times as you want. When we have these living trusts, we do use what we call a pour over will. It's like the safety net will to make sure that any asset we forgot to put in the trust, even if it has to go through probate, will pass to the trust through the terms of the pour over will and be administered according to the terms of the trust. So we don't want anything to have to go through that will. It's just a safety net to make sure that we don't have to repeat all those dispositive provisions of who gets what. We don't have to repeat that in the will. The will just says, hey, if I own anything in my separate name at death, I leave it to my revocable trust. And so then it goes through probate, it passes to the revocable trust, and then gets distributed according to the terms of the trust. Again, the goal is to title everything in your trust, so we don't need that will, but you have to have it as the safety net. All right, a couple of things that are misconceptions about these living trusts. They do not provide any creditor protection. So to get creditor protection through a trust, they generally have to be irrevocable trusts that you can't pull the money out of. You know, there's some states that you can be a permissible beneficiary. You can ask the trustee, which is not you in this type of trust. But for the most part, if you don't want your creditor to get something, then you have to irrevocably give it away and relinquish all your control. Because if you have control over it, then your creditor can get it if they sue you and win, right? So you want to make sure that you understand that this living trust does not provide creditor protection. I see a question, but let me get through this slide and then I'll answer the question. Yeah, that revocability of the trust makes it subject to your creditors. So maybe it provides some level of smokescreen or anonymity, but it's not really used for creditor protection. Can you guys flash that question back up? There you go. Can you not do a transfer on death deed for your house instead of putting it in a trust? You can do that, but there are very few states that have transfer on death deeds. Okay, those are a relatively new thing, and most states still don't have them. So you have to check your own state law to see if that works. Could your parents have just added the car in the pour over will? Well, it was basically in the pour over will because it was left in their individual names after they died. It went through their wills, right? And that was their pour over wills. But because it was going through the wills, we still had to go through probate. So that was what made it painful, was having to go through probate. What should have happened was that my mom had titled that trust when my stepdad died. That car should have been titled in my mom's name and then or in her trust, in her revocable trust. If she had titled it in her revocable trust, then it would have just passed according to the terms of the trust. I could have transferred that car as a gift because all the beneficiaries agreed, and we would have been done in 5 minutes flat. Instead, it took me almost 2 years. So you don't want to do that. You don't want to leave it in your individual name. Okay, so again, as I said, the person who sets up the trust is the grantor. That person is usually the initial trustee. And if you're married, you can either each have your own revocable trust, or you can have a joint trust that then splits into 2 shares when the first person dies, the deceased person's share and the surviving spouse's share. When we do this, we want to name alternate trustees, and I like to go down at least 3 levels. So if, let's say that my revocable trust, something happens to me, I either die or I'm incapacitated. My trust automatically says who will pop in to manage my trust when I no longer can. And so all that person has to do is prove that I'm either dead with a death certificate or that I am disabled with an affidavit of a physician. And then they're the trustee to make those decisions. And you can have one trustee or co-trustees, however you want to do it. And then we talked about that pour over will you need to use in conjunction with your revocable trust. All right. So when you have these trusts, and hopefully you guys got this because I think I've said it a few times, but you have this beautiful trust, 40 pages, 80 pages, whatever it ends up being, 10 pages. In order to make it work to avoid probate, we have to title the assets into the name of the trust or into the name of the trustee. So just keep that in mind, because I can't tell you how many gorgeous trusts I saw walk into my office when one spouse died and said, oh, I need to administer this trust, only to come to find out that nobody ever put any assets into it. So we need to retitle the assets into the trust so that the trust, not you individually, will be the owner. It's really you as the trustee of your trust will be the owner, but not you individually. You, but with a different hat on your head. That's what makes it work to avoid probate. And it does make it a little more tedious than doing a will, because you don't have to retitle things with a will. But makes it more tedious, but you're saving a lot of tediousness and cost in the background when you die. So that's why I call it the ultimate love letters. Get this stuff set up and make it easy for your family. All right, so this is pretty much what I just talked about. Living trusts are a little more complex than a will, so they cost more to set up, but they provide some seriously distinct advantages. You can do disability planning, because if you become disabled, the alternate trustee automatically kicks in and starts managing the assets without having to go for a guardianship provision or use the powers of attorney. If you own real estate in more than one state, then this living trust becomes very, very important, because real estate is subject to probate in the state in which it's located. So if I own, right now, I have real estate in North Carolina, Kentucky, Virginia, and New York. Well, if all those things were in my separate name and I die, that would be 4 probate actions, one in each one of those states. Instead, they're either in LLCs, where my trust is the member of the LLC, or they're deeded directly into my revocable trust. So when I die, all those properties in 4 different states will just seamlessly pass to my beneficiaries without the need for probate. Huge time saver, money saver, headache saver. Really, really great. All right. Thanks, Victor. I see a note from you. Appreciate it. All right. I know we're probably running out of time, so I want to, what time do we have? Yeah, about out of time. I think we just said about the ancillary. All right, we have a question. Revocable trust set up for my parents with my father's social security number, even now after his death. Is this a relevant issue to deal with in any way? When your father died, you should get a new tax identification number for that revocable trust, which became irrevocable. Well, I take that back. You said for your parents. If your mother's still alive, I can't answer the question without knowing how the trust is set up. But if any part of that trust became irrevocable on your father's death, it needs its own tax ID number. It becomes a separate taxable entity. So that's a question for the lawyer, because I can't answer it without seeing the document. Okay, we talked about the Secure Act a little bit. I just want to hit on this, and I think we're pretty much done, and we can take whatever questions at the end. It used to be that if we left an IRA to a beneficiary or to a trust for that beneficiary, we could use their life expectancy in many cases to stretch out the length of time that they had to take money out of that retirement account. And the goal was that they had to only take out the minimum amount, so we didn't increase income taxes for them. They could always take out more, but what was mandated, we wanted it to be as small as possible. Well, the Secure Act a few years ago eliminated that stretch out for all beneficiaries who aren't your spouse, unless they meet some certain rules, like they're disabled or they're minor children or things like that. So now inherited IRAs must be fully distributed to their non-spouse beneficiaries within a 10-year period. If the account owner died after they were already required to start taking distributions, then the beneficiaries have to take distributions starting in year 1, 1, 2, 3, 4, 5, 6, 7, 8, 9, with the whole thing being distributed by year 10. If it's a Roth IRA, we don't have to do that, because nobody has to take money out of their Roth IRA while they're alive. So they never meet their required minimum distribution date. The beneficiaries still have to take it out in year 10, but they can leave it in there to grow until year 10. Okay. So this is a complicated subject in and of itself. I just want to issue spot on this. And it used to be that we could use trust to protect the beneficiaries, still get the stretch out. That is pretty much gone. So I'm not going to go over that anymore. Last slide. Just remember, the failure to plan is a plan. Feeling immortal is not a plan. Thinking you have plenty of time is not a plan, and that your estate plan is your ultimate love letter. Just do it. Your family will thank you. And if you need to reach me, there's my contact information. And now I'm ready to take any other questions you have, Colin.
All righty. That was fantastic. So much engagement, guys. And I did hold a few questions for the end, some that were slightly off topic, and then there were a few tax questions. I guess we can bring those up if you want to tackle them here. I'll go ahead and start putting those up, though.
Yeah. So what and when should you use a land trust? A land trust is another form of a revocable trust, but it is different than the estate planning revocable trust. Most people who use land trusts use them, they're investors, and they use them for one of two reasons usually. Either because they're wheeling and dealing a lot and they want to be able to do things quickly and efficiently without having to redeed properties. They can just put the house in a land trust, and then if they want to sell the house, they don't have to actually redeed the house. They can just change the beneficiary of the land trust. Makes it pretty easy to do that. The other reason people do it, a lot of people erroneously think that a land trust provides creditor protection for you. It does not. Just like the revocable trust, you can control it so your creditors can get it. What it does for you, generally speaking, though, is provide us anonymity or a smoke screen. The trustee is not you. It's usually somebody else. And that trustee is prohibited from disclosing the beneficiary, which is usually you or your LLC. They're prohibited from disclosing that beneficiary. So if someone goes to a lawyer to try to sue a land trust, the lawyer doesn't know who the beneficiary is, whether they have deep pockets. It's not the low-hanging fruit. They're going to go try find somebody easier to sue. So it can provide hurdles for plaintiff lawyers to jump over, and it might defer some lawsuits, but it does not provide actual creditor protection. So people use it. Let's say I had 1,100 single family rentals. I know somebody who has that. I don't want to set up that many LLCs because it's super expensive. So maybe I want to, for every 10 houses, I have each one in a separate land trust. And then those land trusts have one LLC as the beneficiary, and it keeps working its way up. And so for every 10 houses, maybe I have a new LLC as the beneficiary. There are all sorts of ways it can be used, but the key thing is to realize they're great for flexibility, but not so great for creditor protection, other than a smokescreen and hurdles, if that makes sense.
Absolutely. And I'm going to go ahead and pull this down just so that we're kind of on the screen a little bit bigger. I did go ahead and put Mary's contact information there, everybody, on the comments. And we still do have some more questions. So let's.
Sure. I love questions. All right. Oh, what is the maximum amount a person can give to charity each year before it becomes an IRS tax return issue? Well, first of all, I have to disclaim, I am not a CPA. I don't do tax returns. But my recollection, and you should need to check with your CPA about this, is usually it's tied to a certain percentage of your adjusted gross income. So it's not that it's an IRS tax return issue so much as how much can you deduct from your taxes. If you're using your charitable donations to try to reduce your taxable income and your tax burden, how much can you deduct each year? So my recollection, and it's been a while since I've looked at this specifically, is that you can deduct up to, I want to say, 30% of your adjusted gross income for non-cash distributions, gifts, and that can carry forward, I believe, for 5 years. That's the last time I looked at it. Confirm that with your CPA, because I'm
and I was going to say something along the same lines. That's definitely a question more geared towards your CPA, your tax advisor.
Yeah, that's a tax question. I'm just telling you what I remember from the last time I looked at it and from my own experience, but as a giver, but I would check with your CPA.
Okay. Let's see. What else do we have here? There's a couple other tax questions. I'm not sure if you want to try to tackle this one. It is geared more towards estate taxes.
So the question is, I thought that the credit for estate taxes was portable to your spouse. And if you filed estate taxes, even if nothing is owed, then what you did not use could be used when the second spouse dies. Absolutely. Do you remember I said there are 3 ways that we could make sure we're using both of the credits? This is one of them. I didn't get into any details because this could be a whole day-long presentation. But essentially, under the current law, let's say it's 2026. Let's all hope we live to 2026 at least. And each of us could leave $5 million indexed for inflation. So, and I'm just going to call it 5 million for ease of this. So I have 5 million. My husband has 5 million. We're going to pick on my husband this time. He dies first, and everything he has comes to me. So I have his, and he has $7 million. He leaves me $7 million. I've got $7 million. Now I've got 14, which is way more than the 5 I could pass myself. But if at the time he died, I filed an estate tax for him, state tax return for him, and I checked a box that basically says, hey, I want to reserve my right to go back and use my spouse's $5 million estate tax-free amount. then his credit ports over to me. I get to use it. And so now if he has 5 million and I have 5 million, I could leave 10 million indexed for inflation free of estate taxes because I got to use his. The danger of that is that it counts on the surviving spouse remembering to file an estate tax return when no estate taxes are due and to check the box reserving that right to go back and use the credit. So I always worry that that won't get done. So there's another way too called a disclaimer. I'm not going to go into it, but basically when you're talking to your estate planning attorney, this is the type of thing you have to decide is what plan do we set up to make sure both credits are being used? Are we going to do an automatic credit shelter trust so we know 100% it will get used? Are we going to do portability where we're relying on the spouse to check the box? Or are we going to do a disclaimer type plan where we're also relying on the surviving spouse to do what's called a disclaimer, which is to say in writing, hey, I don't want that asset. It's going to make me have too many assets for estate taxes. Put it in a credit shelter trust. So there are really 3 ways. And which way is right depends on your personal circumstances. But that absolutely does work if somebody files the return and checks the box.
Great. A few more here.
Yeah. So please explain what is meant when someone says own nothing, control everything. Is this practical? Thanks. I have a lot of investor friends that say this, and I tend to think a little bit differently. So the reason they say it, they want to own nothing but be in control of everything. So what does that mean? It comes up a lot, like, let's say vacation rental arbitrage. Somebody says, well, I don't want to own this house because then I'm responsible for property taxes and insurance, and I'm on the chain of title for environmental conservation problems or liability or whatever. So I'm going to go rent this house from Colin. I'm going to rent Colin's house, and then I'm going to turn around and rent it on Airbnb for more money than I have to pay him in rent. So I control it because I'm the lessee. I'm leasing that house. So I'm in charge of that house, but I don't own it. So Colin still owns it, and he has to pay the property taxes and the insurance and replace the roof when it fails and all that stuff, but I control it. So there are people who do that very successfully, and that's part of that's the way they like to operate their business. I'm a little bit more of a control freak myself. I want to control it forever. And the only way to do that is to own it because the lease is going to end. They may terminate the lease. I don't know what's going to happen. So it's totally a personal choice whether you control something because you own it or you control it because you're on the lease or you have an option or something else without ownership. And it all depends on your situation.
Okay, we do have time for just a few more questions. So
I answered this one earlier.
Did you?
I can't answer that question without seeing the document, but if any trust became irrevocable, it will need its own tax ID number.
Okay, let's see. Here's another one.
Can the beneficiary designation statement be presented with just a death certificate and an ID to claim the asset? Is that simple? Generally speaking, yes, it is that simple. Because the beneficiary designation is the document by law that says when I die, like if I had my IRA and Colin was my beneficiary, it would be right there. It said, when I die, Colin's my beneficiary. So all Colin has to prove to Quest Trust is that, hey, Mary died and I'm her beneficiary. Here's my ID. I need a check. Right? Perfect. Or roll over it to an inherited IRA. So it is pretty much that simple.
Okay. Land contracts.
How does a land contract transfer to heirs? The deed is still in the name of the seller. The deceased is intestate. Is this considered an asset that must pass through probate if the deed has not transferred? So is the dead person the person who is buying the land contract, buying the house on a land contract, or the seller? I kind of need to know which person you're talking about. I'm assuming it's the buyer. So if the land contract has not been fulfilled, and for those of you who don't know, a land contract means, hey, I'm buying Colin's house and we're going to enter into a contract that says I owe him X dollars a month. And when I've fully paid for 30 years or however long it is, then and only then will he transfer the deed to the house to me. Okay. Normally, if I bought a house from Colin and let's say he was seller financing it to me, the house would be deeded to me right away, but I'd owe him under a promissory note, right? Land contract is a promissory note and a contract, but the deed does not transfer. So if the buyer is entered into a contract to buy the house but hasn't fully paid, the house is not owned by the buyer yet. So the house does not go through probate, but the contract does. That's a right. That is a contract right that the buyer has. And so when the buyer dies, if they die without a will, anything they own that's in their separate name will go through the laws of intestacy to whomever the state says inherits. And that contract right is an asset of the estate. It's worth something, right? But you buy that or you inherit that, you also inherit the payments that you have to make, right? Or you have to relinquish it and lose all that money.
Mm-hmm. Okay. The last question here that we do have time for is from Mike.
Okay. How difficult is it for the attorney to get to the beneficiary of a land trust? How can the attorney blow through a land trust? Well, that is a loaded question because it all in part depends on how the land trust is written. If it's written the right way, so let's say, let me set up the scenario. There's a house that is deeded to the land trust. Let's call it the 123 Main Street Trust, whatever it is. Somebody slips and falls in that house. They can go to the Register of Deeds and realize that, oh, it's owned by 123 Main Street Land Trust. In some states, the trustee's name has to be on that deed, in which case they can though skip trace and find the trustee and sue the trustee or sue the trust. But they can't really get any information unless it's discoverable in the lawsuit. So, and I've had a friend that went through this as a trustee. The trust got sued. Trustee gets called into court. They want to know who the owner of the trust is, who the beneficiary is, to see if they're a deep pocket or how much money they can get out of them, right? Because if it's not enough equity in the house, they might want to try to go after other assets. Well, that trust document prohibited the trustee from disclosing the identity of the trust beneficiary or the owner. And so the judge said to my colleague, you need to disclose this name. And the trustee said, well, Your Honor, if I do that, I'm breaching my fiduciary duty to the trust beneficiary. Are you going to indemnify me when I get sued for breaching my fiduciary duty if I disclose this identity? And the judge said, never mind, move on. And so the lawyers never could find out who the beneficiary was or how much money they had outside of that house in the trust. So it can work, but you might have a judge that says, I don't care, I'm going to throw you in jail if you don't tell me. You know, it's a lawsuit. Judges, depends on what they eat for breakfast sometimes, what you're going to get.
Absolutely. Yeah.
And how can an attorney bust through the land trust? I think there was a separate one.
Yes.
It can be difficult to bust through the trust, right? It can be difficult because how can you bust through something you don't even know what it says because you're not allowed to get a copy of the trust. If the trust prohibits it, the attorney can't get a copy of it. They can't find out who the beneficiary is. How do they blow through it? So it can be tough. Now, if the attorney wants to go on a fishing expedition and somehow through skip tracing and other assets that the beneficiary owns, guess and try to bring that person into a creditor deposition, if they get asked the question under oath, what trust do you have any interest in? Theoretically, they have to say, but somebody's got to go find them. So this is why people like land trusts, because they just muddy the waters. There's a lot of smoke screen and a lot of hurdles, but in and of itself, it is not a creditor protected asset. So let's say that house in that land trust had a lot of equity in it. They could if they win a judgment, they can get the equity in the house. It's just whether they can get through the beneficiary's other assets. So if I'm going to use a land trust, I want to put my low equity houses in there. For my high equity ones, I go straight to an LLC personally because they are creditor protected usually.
Right. Great. Well, yeah, I mean, I think that's kind of all the time we have today. I'm sure if you guys do have more questions, Mary, they are more than welcome to email those over to you or get in contact with you that way.
Yeah, I mean, within reason, I'll answer as many as I can. If I get 1,000, I probably don't have time. But
absolutely.
They've got my contact information, so they can email me. And they want to about me. There's more on my website.
I was going to say, I'm sure your website is a great resource too that people could refer to. Yeah. But thank you so much for your time today. We really do appreciate it. Again, it's always awesome to have you on, and you really do provide some great insight, kind of a bit outside of the investment arena. So it's
people don't think about it, and it's just really encourage everybody to think about it. Just think of it as your ultimate love letter to your family, your causes, your whatever. Just go do it. Go do it.
It is incredibly important.
Yeah. Once you do it, and you can sit back and not worry about it. So just go get it done.
That's right.
Okay? All right.
Yeah. Thank you guys so much for being here. I hope everybody enjoys the rest of your Saturday, the rest of your weekend. We really do appreciate you being on today.
Thank you. Bye-bye.
Thanks, guys. Bye.